Small-scale subsistence whaling has been part of the culture of small seaside Japanese whaling communities for centuries. Limited technology meant that the impact on whale numbers was negligible, and the consumption of whale meat outside those communities was rare. In 1946, nations agreed to the International Convention for the Regulation of Whaling, whose purpose was to conserve whales, but with the purpose of maintaining a viable whaling industry. The convention established a body called the International Whaling Commission. After the Second World War, Japan had been economically destroyed by its own military aggression, and whale meat began to be served all over the country in school lunches because there was little other meat available. Whale meat therefore became an item of nostalgia for those baby boomers who came to believe that eating whale meat was a cultural tradition. By 1986, the International Whaling Commission banned commercial whaling. Whaling was only permissible for scientific research. Japan by now had a large ocean-going whaling fleet, which pursued whales into whaling sanctuaries and into Australian waters around the Australian Antarctic Territory. The industry was heavily subsidised and argued that it was maintaining Japanese traditions, even though traditionally Japanese had never hunted in those waters. After the ban on commercial whaling, Japan developed a spurious research program, which was really just a cover for continued commercial whaling. It produced virtually no useful scientific information, and none justifying the killing of whales. No government intervened, but direct activists like Sea Shepherd went out to defend the whales on the water. In 2007, Australia sued Japan in the International Court of Justice for Japan's incursions into Australia's waters and its breaches of the International Convention. If the whaling was genuinely scientific, Japan would have prevailed. The court said, taken as a whole, the court considers that Japanese whaling involves activities that can broadly be characterised as scientific research, but that the evidence does not establish that the program's design and implementation are reasonable in relation to achieving its stated objectives. The court concludes that the special permits granted by Japan for the killing, taking and treating of whales are not for the purposes of scientific research. The Japanese judge, Owada, father-in-law of the Japanese emperor, predictably voted against the majority, and in 2018 Japan left the International Whaling Commission and announced its plans to continue the unlawful killing of these beautiful creatures.